Hello, my true crime lovelies. How are you? We are going to go into day 8 of Donna Adelson's trial. Well, it's day 8 of testimony, so the defense is on. I've got a summary, I've got some clips I want to show you. We're on lunch break. Georgia has just finished her closing, so this is going to be quick. I'm going to run the intro and then we're going to get right into it. Thank you for being here. Thanks to all the members. I appreciate you. If you like the content, please give me a thumbs up and I'll see you on the other side of the intro. Woohoo. All right, opening the curtains got caught. Okay, my notes are on my phone, so I'm gonna look down at the phone. I'm not ignoring you, I promise. So first witness up was Kristen Adamson, who was Wendy's divorce lawyer. She had to withdraw because Dan made accusations and she was going to have to be a witness. She kind of tap danced around that. Dan was threatening to have her disbarred and Wendy disbarred, or at least looked at by the Florida State Bar in consideration of disbarment. That never quite came out of her mouth that way. She discussed that Wendy had stipulated to no relocation. I have hidden assets, question mark. So Dan believed that Wendy was hiding assets. And so once he was supposed to give her X amount of dollars, I think it was like 120, 150 for the house. He didn't give it to her because he thought she was hiding money in a Charles Schwab, I believe, account. And so the difference was like 70 or 70,000. I was going to say $70, like $70,000. Or it was either, or maybe it was 80,000, so the total was 150. Either way, and 10,000 of that included fees for Kristen. He thought that they were hiding it to the point that the lawyer was involved, which is why he wanted to have them disbarred. He wanted to depose Wendy. We learned that no deposition ever happened, despite Donna telling people,
"Oh, it's another deposition, and it's such an infringement on Wendy." And
she never. Grandma motion. So according to Kristen, this was not to have supervised visits with Donna. This was only that he had right of first refusal. So like instead of Wendy calling her mom like, "Hey, I'm gonna go get my nails done, can you watch the kids?" She has to let Dan know first. And then if he's not available, right, he gets to refuse first, and then it goes to Donna, not the other way around, which either way, I'm sure Donna wasn't happy about it. And then she went to Wendy's divorce party. I have to say, I'm biased against this woman. I saw her in Charlie's trial. I didn't like her in this one either. I don't know. She just comes off as standoffish, and it bugs me. I'm just going to say that. Clearly, she is one of the attorneys that represents high net worth individuals, and it sounds like, well, at least according to pleadings from Dan, that Donna and Harvey were paying for that, because Dan in one of his pleadings said, her influential parents or her affluent parents are funding this, which he felt like was making it more contentious. Like if Wendy had to rely on her own funds, it wouldn't be what it was. Then we had Linda Bailey. OMG, did not like her at all. First things first, I know we're not supposed to look at their appearance. I'm not on the jury. That's a rule for the jury. She had beady little eyes and strange teeth. So I feel safe in saying Donna and Harvey did not offer her any sort of veneers. And I'll leave it at that. So first and foremost, out of the gate, she was in trouble. She did not follow the sequestration order. So this is the second witness from the defense. Remember, we had the realtor the day before. And so the rule was an expert can see the testimony of another expert, nothing else. And so the defense claimed they were confused. I don't know how, but she watched the entire testimony. So, but then once, they did a proffer, the judge said ultimately she is an officer of the court as an attorney and he has no reason to believe that she's not being truthful. And so he let her testify, but she, was like, I'm a peer of Kirsten's and we went to school together. Yeah, but you're coming in as an expert. And she's not. So similar to, for those of us who watched Depp v. Heard, when McMuffin sat in on the other counselor for, I can't remember her name, but she just was in the P. Diddy trial, who talked about abuse and intimate partner violence. Who was clearly biased towards what Amber told her. Anyway, she was very dismissive of all of Dan's motions. She said everything except he was pedantic, but basically like he's not a learned lawyer kind of vibe of he, it was very academia what he was doing and not what a trial lawyer would do. The man graduated from Harvard Law School, ma'am. Where did you say you graduated from? But don't worry. I mean, Georgia made quick work of her. When I say she lit her ass up, I can show you better than I can tell you. I'm going to show you this clip. We first go to, it's at the very end. I just want to show you a little bit of what she says to defense counsel, how she's basically trying to drag a dead man. So disrespectful. Let's go.
Continue with your examination.
Thank you, Ms. Bailey, how did the Adelson-Markel divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markel's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think, and responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't.
I stepped on her, but I'm afraid to go back because it's an 8-hour clip. But he drafted them like it was for a law review article. So again, she's referring to his academic experience and his occupation as in academia, right? He's a law professor.
Technically correct. They were verbose. They were hyperbolic. He used a lot of inflammatory language. But when you really looked closely at his requests of the court, there was no there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-exam.
And I want to say, look, she's bracing herself. When someone is using inflammatory language, the other lawyers may not be affected by that. But Wendy's sending all of these pleadings to Donna, and it's flaring Donna up. So she's kind of saying that, negating that, oh, it wasn't that big of a deal. To lawyers, it's not that big of a deal. To Donna, who's paying for all of this, it's a big deal, right? And if there's inflammatory things being said, Donna is taking it personally. Donna is out to win. But I'm delaying you from Georgia lighting up that ass.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, But to the parties, it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason.
that? Do you agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties, it's the most important thing in the world?
To some degree, that's one reason I called Kristen, is Ms. Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get emotion. If I get something, for example, that, although I've never had, something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000
But you're
pages in
not-
front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question.
They're snickering back here, and this is Dan's father, and his sister Shelley is sitting right behind, and she also smirked at this woman being obtuse.
You were asked, let me ask you this. Let's go on to something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law
I've
litigation?
never had anyone murdered. I had in one instance, a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
So offensive. She's trying to put it all on just that person's upbringing, completely being obtuse and missing the point. Sometimes the people involved in the divorce view the situation differently than a divorce attorney who does it every day for a living. They're probably like, oh, I have stories to tell you, you know? Whereas the people who are personally involved in it don't care about how everybody else has handled it. They only know what they are experiencing. But she's intentionally being obtuse, and I feel like the jury gets that.
Exactly, Ms. Bailey. To
Right.
that person, it was a reason to commit suicide, right?
Apparently so.
Aren't these issues raised in these pleadings potential fuel to make
This
people
is-
upset?
I'm trying to show you, Shelley.
Potential fuel to possibly make people upset.
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal, it wouldn't be granted, it was buried in there. But the allegation is, grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't know.
Exactly.
Exactly. So why are you
It should
here?
have been. There was no proof.
It shouldn't have been, in your opinion.
in my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markel wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
I think on that issue, he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay, well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you?
I
And Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is, you go to jail.
No, that's not true.
It's not true. Okay. Ms.
yeah.
Adamson was incorrect on that point, I guess.
Objection, Your Honor. It's not a question to move to strike.
I'll
What is
rephrase
the-
it.
what is
Was
the objection again?
It's an improper comment on the witness's testimony.
Please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was
Yes
the
or no?
$70,000 still due to Wendy. Jail is not a possibility on that. You don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support. And if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever, and then all of a sudden he comes up with money out of his pocket and he pays, he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail.
Right.
If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. There's no jail consequence to the $70,000 to Wendy. It was only the $10,000 to Kristen that could have possibly remotely been a possibility.
Did you
She's talking in
see
circles.
evidence in this case of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendy then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Ms. Adelson, Ms. Donna Adelson, about the relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October, maybe.
Okay.
Several months.
October is when the plotting began.
If Dan Markel had agreed to
Officially.
the relocation, post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen.
Okay, just totally a tangent. Doesn't it look like Donna is in the recycling bin in the shot? Why is it right behind her like that?
right?
Well, obviously.
Okay, that we gotta go back on. Georgia lets it hang to the obviously.
From Ms. Adelson, Ms. Donna Adelson, about the relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law, and I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud, and it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well-
would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended. If that's
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
no, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know?
So Kristen withdrew once that she was accused of fraud. So that's the clearest it kind of comes out on defense case in chief. But if it wasn't serious, as Miss Bailey is trying to assert, why did she withdraw? She was like, oh, I'm going to have to be a witness. No, she was scared her bar license was going to be taken. But let's go back to this expression on Georgia because I interrupted her.
We're shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Did I go past it? I think I did.
Successful, he would have very likely had to pay Wendy's attorney's fees. And filed the motion that accused Kristen of fraud, so she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
it was set for May 15th and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case.
It
Yes?
And he was murdered in July.
Even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Overruled, the witness has provided an opinion. State
Well-
cross-examine.
Yeah,
I
what's
guess
her
my response
expert
to that would
opinion?
be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing, so once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But
So
that hadn't happened yet,
it had not happened yet,
and we'll never know when that was going to happen, because we never got to that point, right?
clearly,
Because he was murdered.
clearly.
May I have a moment to confer, Judge?
Huh?
Okay, she doesn't go any farther than that, but I think you get the gist of what happened there. So then I just want to show you really quickly. He didn't testify in this trial, but he testified in Charlie's trial. It's Stephen Webster, and I've been spelling it wrong. So it's Stephen, like the judge's name. He represented Dan, and I think it's important to hear what he said, because he was hesitant about representing Dan, because he was like, oh, great, two attorneys duking it out, right? And he had been filing his own motions, but because she went on and on about how they were inflammatory and bogus, and I just want to give you contrast. I mean, of course, anyone can argue he's biased towards his client, you know, he's biased toward Dan, and the other one is biased toward Donna, because Donna's writing her a check, right? State's writing him a check. But he comes across to me more sincere, believable, credible.
During the time that you were, well, let me ask you, before his murder, when was the last time you had spoken with him?
I spoke to him that morning.
And what was the main goal of your representation of Mr. Markel?
So I had just started my firm, and you know, like any small business, you're scared and you're hungry, and a friend of mine called me, Tor Friedman, and said, I have a client for you. And I was like, okay. And he said he's a law professor. And I was like, okay. And he said, it's a family law case. And I said, well, Tor, I don't do family law, and you know that. And he said, well, it doesn't matter. He's a law professor. He'll teach you everything you need to know. And I said, okay, well, that makes sense. So I agreed to meet with him. And the night before, I read all the papers, and they were voluminous. I printed them and actually read every word. And we'd already set up a meeting at Voodoo Coffee on Tennessee Street. And I really didn't think I was going to accept the case. I could just tell from the tenor of the papers that it was really, really contentious. And it just didn't feel like something I probably wanted to get involved in. But I wanted to meet him anyway. And so I met him, and I liked him. I liked him a lot. And so I decided I would take the case. I mean, it's not a prerequisite that I like you to represent you. But in something like that, I didn't want to get involved in a contempt type case with law professors, where ultimately it could end up being disrespectful to the court. And I didn't want to be involved in something like that if I really felt like it was going to be that kind of a relationship. But when I met him, I didn't feel like it was going to be that way. And so I agreed to take it. And his primary concerns were he wanted to get more time with his children, if at all possible, but he didn't want to change the kind of the time sharing. He had a kind of an unusual request. He wanted to see if there was any way that he could see the children every night when he didn't have them, to tuck them into bed and kiss them goodnight. And he said, look, I'll only stay 5 minutes. I promise I won't bother anybody, and I'll leave. And I said, Dan, that's probably never going to happen. That's just probably not reasonable. And then he was really concerned about parental alienation, which at the time I wasn't really familiar with it. I didn't do family law, but I was familiar with it from the perspective of I learned about it in law school and stuff like that. But he was really concerned that the grandmother, Donna Adelson, was really trying to drive a wedge between him and the children. And he actually told me that he heard her refer to him as stupid on a Skype call. He couldn't see her in the Skype screen, but he heard her say something to the effect of stupid's on the phone. And he was livid about it. And he was ready to basically kind of go to war over that.
Did that sort of reference the filing that we're familiar with, where grandma says you're stupid, and he's seeking to have grandma enjoined from having unsupervised contact with the kids?
Yeah, and I didn't have the opportunity to actually talk to him about that yet because he was killed. But it was my understanding that after that filing, he heard her. Actually, he heard her, because that's what he told me. He said, I heard her call me stupid. But she wasn't in the screen, but he knew her.
I'm not sure why Rashi didn't object. That's clearly hearsay. But anyway, you guys get the gist of that, right? So he was concerned about it after he said he could tell from the filings that it was highly contentious. So I know there was a motion in limine. We went over it on this channel to not have him speak, or if he did, it would be like none of his opinions, etc. I was hoping he would get heard on rebuttal after Linda Bailey testified, but I think Georgia did well in sort of, I love Georgia's mind. It's like a steel trap, and so she thinks of every excuse that I'll say opponent might come up with, might offer, and she's ready with like logic. What about this? Well, why would they you know what I mean? I love it. So anyway, that was Stephen Webster. He testified in Charlie's trial. Rashi did not put in motion in limine to have him not testify. So he also very much humanized Dan in a way that he hadn't been humanized in the prior two trials. So I dig him. He's on Surviving the Survivor a lot. He and his law partner, who was a student of Dan Markel. So next in our roster, we had Marisel Descalzo, who we had seen previously. So she represented Donna when Donna was first arrested and prior, after Donna gave Rashi up to Charlie. And she came in hot at Donna's first appearance in front of Judge Everett, where she was, they weren't cooperating. She couldn't have any video visits. The sheriff was there, that like a bunch of people were there, and she was like, the only reason I got to see my client is because of the state and Georgia Kalperman helping me out. It was obvious she was an out-of-towner, right? She didn't know the ropes, and she was coming in hard and heavy of like, you better do this for me. And they were like, girl, if you don't take a number and have a seat. But in her testimony, she was much calmer. I mean, there's less at stake for her being a witness, like, fair enough. She was very credible. I think the key takeaways for me were that the travel arrangement, so they had put in their motions, right, or in their pleadings, whatever we're calling it, that it had been committed to her that Donna would be able to turn herself in, which it turns out she heard from Rashbaum. The most pivotal piece was the part about Donna making travel arrangements. The discussion she had with her was prior to Charlie's conviction, which I feel like the defense left that out intentionally. They didn't allude to it, or they alluded to like it was all in conjunction with this, with her making the travel plans. But I think it's interesting because the jury has heard where Donna is on the phone, that hot mic, right, where Charlie hung up, but she wasn't sure. She didn't hang up because she said, I talked to Dan, meaning Rashi, and he said, knowing what they're thinking up there being Tallahassee, I might make it out. So I want to just share this with you guys because they didn't address this. And I will say, I originally, when it happened, thought like, why is Rashbaum not on anybody's list? Well, when it initially happened, I thought he's going to have to step down because now he's going to be a witness. Like just what Kristen, the reason she says she had to step down was because she was going to be a witness. But can I get a witness? Let's listen in.
Do I want to go to sleep and not see my son? I do. Perfectly honest, I do.
Oh, I want to give credit to Pretty Lies and Alibi. She has the best audio on these calls. So I am using her video. I encourage you to go over there. Gigi McKelvey is a rock star in the true crime world.
And we'll do it together. We'll do it together. Leave a note. They'll know when to come and get us. And we'll do it together. So the boy, look, got to make a decision at some point. So after speaking to Dan this morning and knowing what they're thinking up there, I don't know if we'll make it out in time. I really don't. But Dan said, you might, or you might do all of it, get to the airport, and they'll stop us. And that could happen. It could happen. I don't know, but it's worth a try.
but it's worth a try. And speaking to Dan and knowing what they're thinking up there. And that one, so it all comes full circle. She's talking to Annie Cunningham and Ron Gutterson. So in our last video, we talked about them testifying, right? So they're coming over to help with estate planning after Wendy is ignoring Donna and doesn't want to talk about the case. And Donna's like, this isn't about the case. There is no case. Oh, yes, there is, girl. So Descalzo was, I feel like, coming in to kind of tamp that down. But once she said it was before Charlie's conviction, for me, all bets were off. We'll see what the jury decides. Next up was Sarah Newhouse. She was a victim advocate who talked to Wendy during her now infamous interview. We know it was not an interrogation because she was not a suspect, as Isom told her multiple times. And then the victim advocate was basically testifying as to Donna's, how she sounded on the phone when Wendy called her during the interrogation. So the other part was she had to give a waiver of attorney-client privilege on specific items for Descalzo to talk about. And then the state came back with Patricia Byrd was not on any witness list, so they went round and round about it. Like I said, I just watched Georgia's closing. They mentioned Patricia Byrd in there, so I don't know the legal significance of why they were saying that. So then comes the question, I know you guys all know the answer by now, but of whether or not Donna's going to testify. Now, the defense was going on about she needed more time. Judge Everett was having none of this. I was in Emily's chat, like, she had 11 years, so I don't know why she would need more time. But to be fair, in this immediate instance, they had a long 3-day weekend. We got out early on Monday. Why did you need more time? But the judge, was like, I'm tired of talking to you attorneys, Miss Adelson, and get your ass up here. Section coming up. But so there were several instances, though, where she was given time, right? So we had that the defense was blaming the noise in the gallery as to why Donna couldn't make a decision or why it's weighing on her decision. Then there was another, like at 5:42, will she testify? She was given more time. I think they gave her 5 minutes, and then now we're coming back from the 5 minutes. So it was like, for content, it would have been great if she would have testified, but probably the smartest thing she's done so far. Okay, here we go. I see the judge there. Uh-oh.
Remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of that.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
It's not a game show, girl. Do 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 do.
Judge, since I was handling the prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
If anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity at this point. The colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adamson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these 2 rights?
This time I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against.
I found it interesting. She said, at this time, ma'am, this is the only time you're going to get to have this answer. So this is it. But so they went on to do that. And then it was a little bit of a hiccup because then the defense said they did not rest and they wanted to add in a 2013 journal entry to show that Donna had previously put things up for sale. So as context, the state has offered that as part of Donna's vacation to Vietnam, she was putting up things for sale. She had a list of things for Wendy to sell while they were on vacation. And so the state argues that clearly that's not what we do before we go on vacation. They weren't planning on coming back. There was things like a gun, etc. So the defense wanted to admit these journal entries from, I believe it was 2013, that's what I have in my notes, of where Donna had attempted to sell these things before, right? Compared to 2023, it was like 13 years ago. And that was the journal entry that also had Dan Markel's license plate number and his car type, year, etc. So the entire journal, or the journal in its entirety, had not been entered into evidence. So the judge was like, there's no foundation for this. I think they tried to get it in at that point because had Donna testified, she would have been able to establish the foundation for it. But now because she wasn't, because they had already said they were ready to rest, they just needed to know if Donna was going to testify. So it was a little bizarre. It wasn't allowed to come in. So then they went over the jury instructions and they were told they had 2 hours for closing. So like I said, I just watched Georgia's closing. She's got 7 minutes left. So 2 hours included argument and rebuttal. She's got 7 minutes. She did ask for more time and the judge said yes. So we shall see. But if you haven't seen her closing, I definitely recommend it. She's brilliant. I don't say that about everybody. She's brilliant. And beautiful to boot. So a force to be reckoned with. I've said from the beginning, in Georgia, I trust. I know there are other YouTubers who were very critical. Oh, you should have done this. You should have done that. She's won them all. She's gotten them all one by one. So I'm all right with that. Let me know your thoughts. How are you doing? Are you ready for the trial to be over? I feel like today's verdict watch. I hope we get a verdict by 5 o'clock, but time will tell. All right, I'll talk to you guys later. Toodles. Thanks for being here. I appreciate you.